Good day. My name is Stephanie Salb, and I am a private practice attorney here in the greater Atlanta area. I've been privileged to help clients in crisis since 1993 when I was admitted to the Georgia bar. Divorce, custody, and adoption are my specialty areas of practice and have been since 1993. Without a doubt, one of the most challenging areas of family law litigation is the determination of child custody. And so today we are going to talk about child custody determination in the state of Georgia. There are two components to custody, the physical component and the legal component. The physical component is what you think of when you hear the word custody. It's where the children reside at any given time. The most common arrangement is primary physical or a larger amount of parenting time with one parent and then some visitation for the other parent. Now, when two parents have roughly equal amounts of parenting time, they have what is commonly referred to as joint physical custody. So the other component is legal custody, and it involves two different sub-areas. One of those areas is going to be the right of both parents to get records from doctors, teachers, coaches, and to consult with any professional that is assisting their children. The other sub-area is decision-making. When a dispute arises regarding a child and the parents are no longer living together and can make that decision harmoniously between themselves, there has to be some kind of mechanism to resolve the dispute. And if parties have joint legal custody, they typically have joint legal decision-making. However, there has to be some way to resolve a dispute that comes up regarding the children. Now, the four areas of dispute are non-emergency health care, education, extracurricular activities, and religion. Now, it's very common for divorcing parents to split up these areas. For example, one parent may take final decision-making authority on two of the areas, and the other parent will have the other two areas. Or it could be a combination of 3 and 1 or something like that. What is also very common, however, is if one parent has primary physical custody, then that parent would have final say on all of the areas of decision making. However, if the parties share joint legal custody, then the parent with primary physical custody would have an obligation to consult with the other parent in good faith in an attempt to reach a consensus regarding the dispute. And in the event, after a good faith consultation, they were unable to, then the parent with primary physical custody will have the final say. Now, as with any issue in divorce, the issue of child custody can be agreed to by the parties instead of the judge. Now, if they cannot agree on any areas of decision-making or physical custody, then the judge will have to decide those issues for them. So what does a judge look at when deciding custody? There are numerous factors, and a lot of them are contained in the child custody statute that is found in our official code of Georgia. Now, some of these factors are who has been the primary caregiver of the children, each parent's work schedule, including travel if the parent must leave town frequently for his or her work, each parent's home environment and ability to care and nurture for the child, each parent's physical and mental health, each parent's emotional ties to the child, each parent's ability to provide the child with clothing, food, and medical care, the relationship between the child and any siblings, half-siblings, or step-siblings that may reside at either parent's house, each parent's familiarity with the health, educational, and social needs of the child, each parent's involvement with the child's schooling and extracurricular activities, each parent's willingness to foster a relationship between the child and the other parent, the relative stability of each parent, any history of substance abuse by either parent, any history of physical, sexual, or neglect of the children by either parent, the presence of any domestic violence between the parents, and finally, any criminal histories of either parent. Because custody issues are decided by a judge and not a jury in Georgia, it is very important that your attorney know the habits and leanings of the judge that your case is assigned to in order to advise you of your best course of action. Each judge has his or her own perspective and life's view that will influence his or her custody decisions, and it's vital that your attorney be aware of what these factors are. Now, at the age of 14, a child can select which parent he or she wants to reside with, subject to approval by the judge. Now, between the ages of 11 and 14, the court can consider the wishes of the child, but does not have to be bound by it. Because there is so much at stake when custody of children is an issue, it is vital that you select an attorney who is experienced and knowledgeable in this particular area of law. I hope you found this information helpful. If you ever find yourself in legal crisis, please contact our office. We will be glad to help you shoulder the burden of your legal action.